This video will tell you what mediations are all about. It will explain the mediation process, and it will also explain the difference between mediation and arbitration. Mediation is a confidential settlement process. In most cases in Ontario, parties have to go to mediation. The mediation process involves a third-party mediator where the parties try to resolve their case on a mutually agreeable basis. Mediation gives the parties the chance to come to a settlement on their own terms. Oftentimes, parties find it difficult to have a settlement discussion on their own with the other side, and that's where the mediator steps in. Through the assistance of the mediator, parties can come to a solution that is a win-win one for both of them. If they don't resolve their case, either at mediation or at other points during the lawsuit, the case will ultimately be decided by a judge, who will have to determine the case according to the law, and the parties might not like the decision. Mediation allows the parties to decide for themselves how they would like to resolve the dispute. Mediations can take place at any time during a lawsuit, or in fact before the lawsuit even begins. But most of the time, mediation will happen after examination for discovery, because that's when both sides will have a better idea of what their case is like and how strong the other side's case is. The parties will both agree to the mediator. Now, that could be a retired judge, a respected lawyer who's independent from both sides, or a third party with some expertise in the subject matter. The parties themselves choose the mediator and pay for the mediator from their own pocket. They are not paid for by the court. The mediator cannot force the parties to settle. In fact, the mediator can't make any orders at all. The process is voluntary in that if the parties don't want to settle their lawsuit, they don't have to. They can go to trial and have a judge determine it. They just might not like the outcome. Mediations can work in a number of different ways, and many mediators have different styles that work for them. Generally speaking, though, people will gather together in a boardroom such as this. The mediator will sit at one end of the table and explain the process to the parties to make sure that everybody understands what they're about to get into. Some mediators will ask the lawyers to give a short synopsis of their case, others won't. Some mediators will actually explain their understanding of both sides' cases so that everybody knows that the mediator knows what's going on in the lawsuit. At some point in the day, the mediator will usually separate the parties out so that they can have confidential discussions amongst themselves, and the mediator can shuttle back and forth between both sides to try to come to a settlement that is agreeable. All mediations are strictly confidential. Lawyers refer to the mediation process as entirely without prejudice. What that means is that nothing that is said in a mediation can ever come out in court. You can't say, "But you told me this in a mediation." That is not allowed. The reason for the confidentiality is so that parties can be open and transparent in trying to come to a resolution, without fear that their statements will come back to haunt them at trial. Sometimes there's information that you tell the mediator that you don't want the mediator to tell the other side. If that's the case, you should make this clear to the mediator. Otherwise, the mediator will feel free to relay what you told them to the other side. Bear in mind that the mediator is not your lawyer, is not the judge, and is not on your team. The mediator's role is to try to get the parties to settle for their own good. You should be aware of this when you communicate with the mediator to make sure that what you communicate is in your interest and you are not disclosing information that you should otherwise keep to yourself. The parties pay for the mediation. If there are two parties, both sides pay 1/2. If there are three, everyone pays 1/3. The mediator's fees are to be negotiated with the mediator directly. Some mediators will charge quite a lot of money because they have a track record of settling cases. The mediator's fees should be negotiated directly between the lawyers and the mediator. Not all mediators charge the same amount of money, and some mediators can be quite expensive. You should prepare for a mediation by meeting with your lawyer and talking about the options that are available to settle the lawsuit. Very often, people will approach a mediation thinking about what is their best outcome? What would they like to achieve? Or what do they need to achieve through the lawsuit? That's not the best way to approach a mediation. The best way to approach a mediation is to think about what will happen if you don't settle. What will happen if your case goes to trial? And what will happen if you're not successful at trial? It's easy to imagine how great life would be if you succeed at trial and you won beyond your wildest imagination. But you have to approach a mediation from a realistic standpoint. And the mediator will remind you of this. The mediator will talk about your best alternative to a negotiated resolution. In other words, if you don't settle this case today, what's likely to happen at trial? How much is it going to cost? How long will it take? And how much stress will you have to endure before you get your result from court, if you are successful? Thinking about the process from that perspective helps keep you realistic in terms of what you might be able to achieve from the mediation. And hopefully the other side will be approaching the case from exactly the same perspective. Many people confuse mediation and arbitration, and in some respects they are similar. However, in one respect they are very different. A mediation, as I've already indicated, is a voluntary process. The mediator has no powers to order any result on the parties against their wishes. An arbitrator, though, is like a private judge. When you agree to arbitration or you're forced into arbitration, the arbitrator has the power to decide your case, whether you like it or not. We hope you have found this video on mediation to be helpful. Thank you for watching.